Fun fact: did you know octopuses have 3 hearts, and their blood is blue? Anyway, do you want to know the right that a seller has under the sale of goods transaction? Well, it can be seen in the case of Rowland versus Divall, 1923, where the claimant, Rowland, purchased a car from the defendant, Divall, who was a car dealer. Rowland bought the car and used it for several months. Later, Rowland found out that the car was stolen before it was sold to him. Since Divall had no legal ownership of the car, Rowland had to return the vehicle to the rightful owner, who had previously reported it as stolen. Rowland then sought to recover the full purchase price from Divall, arguing that he was entitled to a refund because the sale was invalid due to Divall not having title to the car. Issue: whether Rowland could recover the purchase price of the car from Divall, despite having used the car for a period of time, due to Divall's lack of title to the car. Legal principle: the case primarily revolves around the Sale of Goods Act 1893, which has since been replaced by the Sale of Goods Act 1979 in the UK. Under the Sale of Goods Act, there is an implied condition that the seller must have the right to sell the goods, Section 12 of the Act. Since Divall had no title to the car, this condition was breached. The contract was therefore considered to have been a failure of consideration. Decision: the court held in favor of Rowland. The decision reaffirmed that if a seller does not have the legal right to sell goods, i.e., the goods are stolen or the seller has no ownership, the buyer can recover the full price from the seller. The court ruled that Rowland was entitled to a full refund from Divall, despite the fact that he had used the car for several months. The judgment emphasized that the buyer had received no valid title to the car, so the sale was not legally binding. Don't forget to like, share and comment the next case you want on Godwin's Case Diary.